Thank you, Mr. Chairman. Mr. Smith, you've said several times in your deposition that you believe that the facts and the law, your interpretation of the law, would lead to a conviction of President Trump. Is that correct?
Yes.
And did you believe that same thing, that your interpretation of the law, your reading of the law, would have resulted in the conviction when you went after Virginia Governor Bob McDonnell back in 2014? Did you believe it at the time?
I did believe, and
ultimately you got a conviction in lower court, but that was overturned by the Supreme Court, correct?
He thought
Yes.
he had Jack Smith cornered. Ben Cline leans in and asks the question that's supposed to end the whole conversation. Did you have any evidence that Trump's statements actually intimidated witnesses or stopped them from coming forward? And Smith doesn't dodge. He doesn't ramble. He drops one legal reality that flips the table. Because the moment you understand that one fact, Cline's entire gotcha collapses. If you want straight, high-stakes breakdowns like this, hit subscribe real quick. Now, watch how this turns. This wasn't a friendly chat. This was a hearing in front of the House Judiciary Committee. Former Special Counsel Jack Smith is there, and Cline's strategy is obvious. Paint Smith as a prosecutor with a pattern, someone who stretches the law, overreaches, and then loses when a real court finally steps in.
yes, the Supreme Court changed the law on what constituted an official act, and
Actually,
as a
that's
result,
incorrect.
that conviction was overturned.
That's incorrect. They applied the law, and they said in their ruling, our concern is not with tawdry tales of Ferraris, Rolexes, and ball gowns. It's instead with the broader legal implications of the government's boundless interpretation of the federal bribery statute. A more limited interpretation of the term official act leaves ample room for prosecuting corruption while comporting with the text of the statute and the precedent of this court. They accused you of using a boundless interpretation of the federal bribery statutes. Now, did you believe when you went after John Edwards that your interpretation of the facts and the law were correct and that you would convict John Edwards of corruption?
Yes.
But in fact, that case resulted in a jury deadlock on 5 charges and acquittal on another charge. Is that correct?
That is my recollection. That's correct.
Let's move on to the court's interpretation of your gag order requests. Mr. Smith, America was founded on the principle that the government doesn't silence political speech, in particular speech before it happens. You sought a prior restraint against President Trump without a single violation of pretrial release. In fact, there was no real-world harm that you could articulate justified giving the federal government the power to silence him as a presidential candidate, was there?
The court granted those motions and found that the prosecutor did not have to wait until someone was harmed to make such a motion.
Actually, the request was rejected when the case was actually...
So Cline starts where it looks safe. He brings up 2014. He points to the case against Virginia Governor Bob McDonnell. Cline says Smith believed his interpretation of the law would lead to conviction. Smith says yes. And then Cline reminds everyone, the conviction got overturned by the Supreme Court. Hold that thought, because what Cline is really doing there isn't history, it's character framing. Smith responds with his version. He says the Supreme Court changed the law on what counted as an official act. Cline snaps back. He insists the court didn't change it, it applied it, and criticized the government's boundless interpretation of the bribery statute. That phrase, boundless interpretation, that's a loaded weapon in a hearing like this, because Cline is building a story. You did it before, you're doing it again. Then he pulls the John Edwards case. Same move, same shape. Did you believe your interpretation was right? Smith says yes, and Cline points out the result, a jury deadlock on 5 charges and an acquittal on another. So now the setup is complete. Cline wants you thinking, this is a guy who swings big, says he's right, and leaves wreckage behind. But here's the trap. Those examples are not actually about what Cline wants to talk about, because Cline isn't there to debate bribery statutes or official acts. He pivots to what he really wants, the gag order request against Trump, and he frames it in the most explosive way possible. He calls it prior restraint. He says America was founded on the principle that the government doesn't silence political speech, especially before it happens. Then he makes the key claim. Smith sought this restraint without a single violation of pretrial release, and with no real-world harm he could articulate to justify silencing a presidential candidate. That's the pitch. No harm, no restriction, no victim, no muzzle. And if you're listening fast, it sounds like a clean constitutional argument. But here's the part most people miss. Cline is trying to set the standard so high that it becomes unusable, and Smith's answer is basically, that standard isn't the law. Smith says the court granted the motion and found the prosecutor did not have to wait until someone was harmed to make such a motion. That's the hinge. That's not a vibes argument. That's a structural rule about how courts protect proceedings. Cline tries to interrupt the momentum. He argues the request was rejected, then restricted. Smith agrees it was narrowed. But then Smith calmly explains what actually happened in court terms. The district court granted an order, Trump appealed, and the Court of Appeals agreed there was a basis, because threats to witnesses coming from Trump's targeting were real, and there was a duty to protect them. Notice what's happening. Cline is selling restriction like it means defeat. Smith treats narrowed like what it usually is in appellate life, refinement, not reversal. And the details matter. Smith says the Court of Appeals narrowed the order so it covered witnesses, court staff, the judge, and Smith's staff. And the difference? It didn't cover Smith anymore. And Smith says he was fine with that. Hold that thought, because that one sentence is doing so much work. It turns the narrative from silencing a candidate into protecting specific people around a case. And it strips out the emotional hook Cline wants. They're protecting Jack Smith's feelings. Smith is basically saying, it wasn't about me. Now Cline goes for the kill shot question. Did you have any evidence that Trump's statements intimidated witnesses or prevented them from coming forward? Smith answers with what he calls evidence of Trump's statements. If you come after me, I'm coming after you. Then Smith adds something even sharper. He says Trump suggested a witness should be put to death. And he ties it to what the courts found, that statements like that don't just deter witnesses who already came forward. They deter witnesses who haven't come forward yet. That's the core mechanism. That's the part people pretend not to understand, because the whole point of intimidation is to stop the unknown witness from ever becoming a known witness. Cline fires back. You weren't able to identify a single witness who didn't come forward because they were intimidated. And listen to how insane that demand is when you slow it down. He's saying, prove the invisible person exists. Name the person who stayed silent, which is exactly why Smith calls it out in practical terms. He says they had extremely thorough evidence that Trump's statements were having an effect on the proceedings, an effect not permitted in any court of law in the United States. And now comes the moment where Cline's whole posture starts to wobble, because Cline tries to reframe it again as politics. He says it's a pretty low bar if you're trying to silence a candidate for president. If you can't identify a single intimidated witness, maybe you should reconsider. And Smith responds with the one legal fact that shuts down the entire angle. Both courts upheld the orders. And it is not incumbent on a prosecutor to wait until someone gets killed before moving for an order to protect the proceedings. That's not rhetoric, that's a rule. And once that rule is acknowledged, Cline's no harm, no order framework dies on the spot. Because the law, as Smith is describing it, does not require a body to justify protection. Cline tries another lane, internal concerns. Did anyone on your team raise concerns that the expansive gag order would infringe on Trump's First Amendment rights? Smith says they discussed First Amendment issues because he and his staff respect the First Amendment. But then he draws the boundary. The First Amendment does not allow statements that interfere with the administration of justice in a judicial proceeding. And he says his interpretation was supported by the district court and agreed upon by the Court of Appeals, based on the phenomenon of statements targeting individuals and causing threats to happen to them. Then Smith adds the detail that makes all of this feel less abstract. He says in the days after Trump made some of these statements, the district court received vile threats to the district court's life. And in that environment, Smith says, he felt a duty to make the motion, and he makes no apologies. And then, like a button on the whole exchange, Cline says the court stayed that motion on August 3rd, 2024. That date lands like a stamp. This wasn't theoretical. It moved through real steps, real rulings, real appellate narrowing. So let's do a quick micro recap. So here's what we know. Cline's argument is no identifiable harmed witness, no gag order. Smith's answer is, courts upheld it, and prosecutors don't have to wait for someone to be killed. And here's what it means. The fight isn't about whether speech is protected, it's about whether courts can prevent speech from contaminating justice. But here's the part most people miss. Cline's argument only works if you pretend intimidation is supposed to be loud and measurable and neatly documented in a spreadsheet. Like, witness A did not testify because of post B. That's not how fear works. Fear doesn't send you a receipt. Fear sends you home. Fear keeps you quiet. And if fear succeeds, the person you're demanding to see never becomes a named witness in the first place. Which is exactly why Smith's line, "You don't have to wait until someone gets killed," is so devastating to Cline's framing, because it drags the whole argument back to reality. Prevention is the point. Now, the commentary around this exchange makes it even clearer what the leverage shift actually is. The vibe is summarized bluntly: one law for them, another for us. And the critique is that Cline's position suggests prosecutors have no business telling a defendant to stop threatening people unless there's an actual body, unless a witness is literally murdered. That sounds extreme, but that's why it sticks, because it exposes the structure of the argument. Cline keeps demanding proof of harm. Smith keeps pointing to duty and prevention. And then it gets worse, because the commentary highlights the absurdity in plain language. We're stuck explaining basic concepts to grown men, things most people figure out in kindergarten. Don't touch the hot stove. Don't run with scissors. And if you're under federal indictment, maybe don't go online and target people tied to your case. That line isn't just a jab. It's a warning about how low the bar has gotten for what we're pretending is serious constitutional reasoning. Hold that thought, because there's another detail that changes the entire temperature of this. The commentary points to a criminal complaint filed in the Southern District of Texas in August 2023. It names a woman, Abigail Jo Shree, and it says she called Judge Tanya Chutkan's chambers and left a voicemail. "You are in our sights. We want to kill you." Then another line. "If Trump doesn't get elected in 2024, we are coming to kill you." That's not policy debate. That's a threat. And the point being made is simple. That kind of environment is exactly what protective orders are designed to anticipate and contain. Now, you can feel the argument turning, because once you admit threats exist, once you admit rhetoric can trigger danger, the question becomes, what is the legal system allowed to do before violence happens? And Smith's answer, again, is that prosecutors don't have to wait for someone to be harmed, and the courts agreed. And the Court of Appeals narrowing becomes important in a very specific way, because narrowing is the court saying, we're drawing a line that targets protection, not blanket silencing. It's not shut him up. It's protect witnesses, staff, the judge, and the integrity of the proceeding. And according to the commentary, the court's approach is described like this. Trump could still attack Jack Smith personally, and Smith said he was fine with that. So the so-called restriction Cline wants to brag about becomes, in that framing, the opposite of what he wants it to be. It's not Smith getting slapped down. It's the court calibrating what can be said about whom, because the protected interest is compelling. And that's why the phrase core of the gag order matters. If the core survives, the argument that Smith lost is just spin. Now go back to the earlier part of Cline's hearing strategy, Bob McDonald and John Edwards. The commentary calls it a sleight of hand. Because those cases are about the technical definition of official acts and bribery statutes, they're not about whether a defendant can target witnesses and court staff. So the implication...
When you actually were not able to, it was restricted, correct? The gag order was restricted, correct?
Well, we filed for an order in the district court. The district court granted an order. President Trump appealed that order. The Court of Appeals absolutely agreed that there was a basis and that the threats to witnesses that came from the targeting by Donald Trump were real, and that we had a duty to protect them. You are correct in that the Court of Appeals narrowed the order, so the order covered witnesses, court staff, the judge, and my staff. The difference was that it didn't cover me anymore, which I was fine with.
Did you have any evidence that President Trump's statements about the cases against him intimidated witnesses or prevented them from coming forward?
I had evidence that he said, if you come after me, I'm coming after you. He suggested a witness should be put to death. The courts found that those sort of statements not only deter witnesses who've come forward, they deter witnesses who have yet to come forward.
But you weren't able to identify a single witness who didn't come forward because they were intimidated by President Trump.
We had extremely thorough evidence that his statements were having an effect on the proceedings that is not permitted in any court of law in the United States.
Don't you think it's a pretty low bar to clear if you're trying to silence a candidate for president? I mean, if you can't identify a single witness who's intimidated, that maybe you should reconsider the gag order?
Court staff. So the implication is that Cline is using those names as a fog machine. Throw them out to suggest Smith doesn't understand the law, so you'll distrust him when he talks about protecting proceedings. But if those are different categories, then the comparison isn't analysis. It's misdirection. It's meant to trick you into thinking basic courtroom safety is just another boundless interpretation. And here's the trap. If you accept Cline's demand, if you accept name one intimidated witness or you can't act, you create an impossible standard. Because if intimidation works, you don't know who stayed quiet. That's literally what successful intimidation looks like. So the rule becomes, the stronger the intimidation, the less the system can respond. That's not a safeguard. That's a blueprint for mob control. And the commentary pushes it further with a simple reframe. People think this is about free speech. It's actually about whether justice can function when a powerful defendant has a megaphone. Because the moment you normalize speech as a tool to terrorize judges and witnesses, you're not defending democracy, you're building chaos. And once it's built, it doesn't roll back. Hold that thought, because now comes the personal level scenario that makes this land. Picture being a witness. You do your civic duty. You agree to testify. Then the defendant, someone with millions of followers, starts posting about you, targeting you. Suddenly, you're getting threats. Now ask yourself, are you going to keep walking forward, or are you going to disappear? The commentary says it plainly. If the rule is, we can't intervene until you're actually hurt, then the justice system stops working. Because no sane person would testify against a powerful figure again. So the effect isn't just one case. It's a chilling effect on every future case where public attention becomes a weapon. And the commentary throws in a reference to make the point resonate. Ask the Georgia election workers Ruby Freeman and Shay Moss. The point isn't the details. The point is that the targeting is real enough that names like that are invoked as shorthand for what public harassment can do. Now let's do another micro recap, because the story is moving fast. So here's what we know. Cline tries to equate no named intimidated witness with no justification. Smith answers with the court's position. Prevention is allowed, and the order was upheld and narrowed. And here's what it means. Cline is arguing for an after-the-fact justice system. Smith is defending an in-the-moment protection system. And then the incentives snap into focus. Cline isn't just making a legal argument. He's trying to retroactively frame protection as election interference. That's the strategy described. Treat basic safety as silencing a candidate, and you flip the moral story. You make the prosecutor the villain. You make the protective order the crime. You take duty to protect and rename it tyranny. And the second that weapon for the powerful gets taken away, the second they're told they have to follow the same rules as everyone else, the scream goes up. Now, if you're wondering where the one legal fact really bites, it's right here. Smith says both courts upheld the orders. That means this isn't a prosecutor freelancing. It's a judge granting and an appellate court agreeing there was a basis, then narrowing the scope to protect specific categories of people. So when Cline tries to make it sound like an unconstitutional gag was slapped on without justification, Smith's answer is, the courts reviewed it, and they didn't require the prosecutor to wait until someone was harmed. That legal boundary matters because it defines what harm means in court. Harm isn't only blood on the floor. Harm can be interference with proceedings. Harm can be threats that change behavior. Harm can be deterrence, people who don't testify because they're scared. And Smith's position is that those effects are not permitted in any court of law. That's why he calls it administration of justice, because the proceeding itself is an institution that can be attacked. And the weapon is not always a fist. Sometimes it's a sentence. Sometimes it's a post. Sometimes it's a suggestion that a witness should be put to death. Hold that thought, because now the question becomes, What did Cline actually want out of this hearing? He wanted a clip where Smith admits he had no evidence. He wanted a moment where Smith looks like he was trying to silence a political opponent with zero justification. Instead, he got Smith calmly stating that the courts upheld the order was narrowed to protect witnesses and staff, and prosecutors don't have to wait for someone to die. And the more Cline pushes name the witness, the more he reveals the nature of the intimidation problem. Successful intimidation is designed to leave no witness to name. So the low bar line flips back on him, because if the bar is, show me a harmed witness, then the system becomes a machine that only acts after tragedy. And Smith directly rejects that. He says, it is not incumbent to wait until someone gets killed. That's the sentence that ends the argument. Now, you might be thinking, okay, but what about the First Amendment? Smith doesn't pretend it doesn't exist. He says they discussed it and they respect it. But he draws the line. It does not allow statements that interfere with the administration of justice in a judicial proceeding. And he says that interpretation was supported by the District Court and the Court of Appeals, tied to the phenomenon of targeting and threats. So the framing becomes, this isn't speech versus silence, it's speech versus interference. And interference has consequences, real threats, real pressure, real deterrence. Now the ripple effects. If you normalize Cline's standard, you change the playbook for every high-profile defendant. You incentivize targeting because targeting has upside and almost no immediate legal downside. You teach people, push the crowd because the system can't move until someone can prove a specific person stayed quiet. You turn justice into a contest of who can generate the loudest fear without leaving a paper trail. And once that's normalized, it doesn't just affect witnesses, it affects judges, it affects court staff, it affects every person who has to touch a case that could put them in the crosshairs, which is why the narrowing described, witnesses, court staff, the judge, Smith staff, is so important, because it reflects what the system is trying to protect, the people who make the process possible. Now the commentary adds another sharp analogy. Cline's premise is like saying, because the bomb didn't go off, we never needed the bomb squad. That's the prevention principle in plain English. And if you reject prevention, you are choosing risk. You're accepting that the system must absorb violence before it earns the right to respond. And that's the deeper mechanism here. Courts aren't only judging what happened, they're managing what could happen when conduct threatens the integrity of a proceeding. And that's why Smith's no apologies line lands, because he's presenting it as duty, not preference. Hold that thought, because there's one more twist that makes the whole exchange feel even more like a power play than a legal debate. Cline isn't just arguing about law, he's arguing about legitimacy. He's trying to make the audience feel that protecting witnesses is silencing a presidential candidate. That's not a neutral framing, that's leverage. Because if you can convince people that protective court orders are election interference, you poison the well for any future enforcement. You make every attempt to protect proceedings look like tyranny. And then the system starts hesitating, not because the law changed, but because the politics did. That's the danger the commentary is pointing at when it says this normalizes mob rule over the rule of law. Because if justice goes to whoever has the biggest megaphone and the angriest crowd, then procedure becomes optional. And if procedure becomes optional, the whole system becomes negotiable. Now let's...
Both courts upheld the orders, and it is not incumbent on a prosecutor to wait until someone gets killed before they move for an order to protect the proceedings.
Did anyone on your team raise concerns that this expansive gag order you were seeking would infringe on President Trump's First Amendment rights?
My recollection is that we, of course, discussed First Amendment issues regarding this application because I and my staff respect the First Amendment, but the First Amendment does not allow one to make statements that interfere with the administration of justice in a judicial proceeding. My interpretation was supported and agreed upon by the District Court and the Court of Appeals in terms of the phenomena of the statements being made, targeting individuals, causing threats to happen to them. I would also add, sir, that in the days after Donald Trump made some of these statements, the District Court, in this case, received vile threats to the District Court's life. In that environment, I felt a duty as a prosecutor to make that motion, and I make no apologies.
And the court stayed that motion on August 3rd, 2024. I yield back.
Gentleman yields back.
Now let's lock in the turning point one last time, because this is the moment the whole title is really about. Cline tries to force Smith into admitting he lacked evidence of intimidation's impact. Smith responds with evidence of statements, the court's findings about deterrence, and the principle that prosecutors don't have to wait for harm. Cline says the bar should be higher because Trump is a candidate. Smith answers, both courts upheld it, and you don't wait for someone to get killed. That's the shutdown. Not because Smith wins a debate club point, because the legal premise under Cline's argument is rejected by the very structure of how courts protect cases. And once you admit that, the rest of Cline's performance becomes theater. So here's what we know. This wasn't about whether Smith felt offended. It was about whether threats and targeting can distort a case. And here's what it means. The courts treated protection as legitimate, even while narrowing scope, because the risk wasn't imaginary. And now the inevitable question. If the standard is not wait for harm, then what is the standard? Smith's answer, in essence, is interference with the administration of justice is the line. Targeting that causes threats is the line. Deterring witnesses is the line, and the courts, in his telling, agreed. Which brings us to what happens next, and why this doesn't end with one hearing exchange. Because when a sitting member of Congress argues the system should wait until someone is hurt, when he treats no named intimidated witness as disproof of intimidation, he's not just arguing about one order. He's trying to redefine the conditions under which courts are allowed to protect themselves. And if that redefinition sticks, the next time threats rise, the response gets slower, the hesitation gets baked in. And the question becomes, how much fear has to flood the system before anyone is allowed to act? Because if wait until someone gets killed is the standard you flirt with, you're not defending speech. You're gambling with lives inside a judicial proceeding. And the craziest part? Smith already told you exactly how the system sees it. Both courts upheld the orders. They narrowed it, yes, but the core survived. And once that core survives once, the real fight becomes political, not legal. So the next time you see this argument, name the harmed witness or shut up, hear what it really is. It's not a principle, it's a trap. And the moment you fall for it, you've just agreed that justice only gets to act after disaster. So here's the hook you should be watching for. If prosecutors don't have to wait, and courts can narrow but uphold protections, then the next leverage fight isn't whether protection exists, it's who gets protected, and who gets left exposed while everyone argues about whether the threat is real enough yet.